There is a subtle shift that happens when a legal right moves from theory into everyday life. It shows up in quiet moments, standing at a retail counter, filling out required paperwork, sensing impatience behind you. What feels like social pressure can quickly raise a constitutional question about equality, accommodation, and the limits of discretion. Under federal disability law, age-related limitations such as slower mobility, reduced vision, hearing difficulties, or simply needing additional time to read and understand forms are not inconveniences. They can qualify for legal protection. Once those factors are present, the interaction is no longer based on courtesy alone. It becomes structured by enforceable standards. A business cannot lawfully rush a required firearms transaction because a customer needs more time, nor can it deny a lawful sale solely due to the pace of completion. Delays in background checks, even if longer than expected, are part of the regulated process and cannot be treated as inherently suspicious. Consider how a single sentence can alter the balance of a situation. In one example, a man in his early 70s who was nearly turned away after taking extra time calmly invoked his right to reasonable accommodation under federal law. The atmosphere changed. The transaction proceeded. That moment illustrates how legal standards operate not as favors, but as obligations. As you reflect on that example, pause to restate the governing principle in your own words. When does a routine interaction become one shaped by statutory rights rather than social expectations? A similar pattern appears in training requirements and licensing structures. Many people assume that modern certification rules automatically replace older credentials. Yet in numerous states, long-standing hunter education certificates continue to satisfy firearms competency requirements for concealed carry permits. States such as Wisconsin, Virginia, Idaho, Arizona, and Oregon recognize original state-approved hunter education training as valid proof, often without expiration. The legal reasoning here respects documented experience. Individuals who completed formal programs decades ago may already meet current standards, even if they believe a new class is mandatory. Before enrolling in additional coursework, contacting the appropriate licensing office to confirm whether prior certification qualifies can prevent unnecessary expense and repetition. This is not about avoiding regulation. It is about understanding how existing qualifications fit within contemporary statutory frameworks. Notice how the law treats continuity of training as relevant evidence of competence, rather than dismissing it because of age. Track that reasoning carefully. What counts as proof, and why does the state accept it? The same interpretive logic surfaces in fee structures. Some jurisdictions reduce concealed carry permit costs once applicants reach a specified age. In Louisiana, for example, individuals aged 65 or older pay half the standard fee for a 5-year permit, and lifetime permits are similarly discounted. Alabama offers lifetime pistol permits at reduced rates past an age threshold. Texas lowers renewal fees for older applicants. These adjustments reflect legislative judgments about fixed incomes and statistical assessments of risk, as described in the source material. Yet these reductions are often not prominently advertised. If an applicant does not inquire, the standard rate may apply. The broader lesson is that statutory benefits can exist quietly within the code, activated only when understood and invoked. Now consider how age-based exemptions operate in hunting regulations. In some states, once a resident reaches a certain age, the obligation to purchase a hunting license changes significantly. Florida provides a clear illustration. Residents aged 65 or older may rely on a standard driver's license as authorization for hunting and fishing activities, eliminating the need for separate annual payments. Georgia uses a birth year cutoff. Those born before January 1, 1961, are exempt from certain hunter education requirements altogether. These provisions reflect legislative recognition that earlier generations often acquired firearms safety through extensive hands-on experience before formalized classroom programs became widespread. The structure of these exemptions reveals a key interpretive principle. Lawmakers may treat experience as an alternative pathway to compliance. Before assuming that a requirement applies uniformly, reviewing the specific statutory language can clarify whether a birth date or age threshold alters the obligation. At this stage, compare how two legal mechanisms operate differently, a fee reduction based on age versus a complete exemption tied to birth year. Both rely on categorical distinctions, but they function in distinct ways. The same analytical framework extends beyond licenses. Some national firearms advocacy organizations reportedly offer discounted membership rates for seniors, particularly for lifetime memberships, while maintaining identical benefits. The underlying idea is consistent. Pricing structures may shift with age, yet the substantive rights and services remain the same. The key is awareness of the policy as written rather than assumption based on standard rates. Another area where misunderstanding can have lasting consequences concerns the belief that advancing age alone affects the right to possess firearms. According to the source material, there is no federal rule that automatically disqualifies an individual from firearm ownership because of age, whether at 60, 70, 80, or beyond. Removal of that right requires formal judicial action, including due process and a specific finding of mental incompetence. A medical diagnosis, medication use, mobility limitations, assistance with finances, or residence in assisted living does not by itself terminate constitutional rights. Even guardianship in many states does not automatically revoke firearm rights, unless a court explicitly orders it. Federal courts, as described, have reinforced that age-related decline alone is not a valid basis for stripping constitutional protections. Here, the governing concept is procedural safeguard. Rights are not forfeited through assumption, they are removed through adjudication. Consider how this principle interacts with fear and social pressure. Many individuals reportedly relinquish firearms voluntarily because they believe aging makes ownership unlawful even when no court has acted. Once surrendered, restoring rights can be difficult and uncertain. Reflect on the distinction between voluntary surrender and court-ordered prohibition. Tracking that difference clarifies why due process matters so deeply in constitutional reasoning. A related example underscores how regulatory changes can affect seniors in unexpected ways. In 2017, a rule associated with Social Security benefits would have allowed individuals with representative payees managing their finances to be reported to the federal background check system as prohibited persons without a judicial hearing. The rule was repealed before full implementation. The repeal reinforced the principle that needing assistance with financial management does not equate to mental incompetence and cannot alone justify loss of constitutional rights. This episode illustrates how administrative classifications can intersect with fundamental liberties and why oversight and legislative review play essential roles. Finally, consider how federal and state authority interact in specialized contexts. Retired law enforcement officers occupy a distinct legal category under the Law Enforcement Officer Safety Act. According to the source material, qualified retirees who served at least 10 years or retired due to a service-related disability may carry concealed firearms nationwide, provided they maintain official identification and complete annual firearms qualification. This federal statute preempts conflicting state requirements, meaning that states cannot impose additional permitting obligations on those who qualify. Challenges have arisen, including attempts by certain states to require separate permits, but courts have recognized the statute's supremacy in this context. The interpretive issue here centers on preemption, when federal law overrides state restrictions. As you think through that doctrine, note how eligibility hinges on clearly defined criteria rather than discretionary approval. The closing example brings the analysis back to everyday life. For retirees traveling in recreational vehicles, legal classification can change based on context. When an RV is parked and used as a residence, many states treat it as a home, and typical home defense storage rules may apply. Once the vehicle is in motion, however, it is legally treated as a vehicle, triggering stricter transportation requirements that may include unloading, securing, or placing firearms out of reach unless a recognized carry permit is held. The same physical space shifts legal identity depending on whether it is stationary or moving. That transformation has led to serious consequences for individuals who assumed consistency where the law recognizes distinction. The broader lesson is one of precision. Rights and responsibilities often turn on defined categories: disability accommodation versus courtesy, qualification versus assumption, adjudication versus rumor, residence versus vehicle, federal authority versus state regulation. Understanding how courts and legislatures draw those lines is not about seeking advantage. It is about recognizing that constitutional interpretation operates through structured reasoning, and that careful attention to legal standards can prevent misunderstandings that might otherwise carry lasting consequences.